Greetings, salutations, my fellow sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and 70 class, and tonight we were going to be talking about due process, and we've been talking about due process now for quite a while, and been reading from a treatise specifically about due process, and this will be the 8th class. We're going to try and get through this whole entire thing for those who are very interested in making sure that they do everything regarding due process correctly in the courts, because if you don't, well, then you can't get a default judgment. In fact, you can't get any judgment at all, particularly if you have not properly served the other party. And if you'd like to join us at Vocational Science Freedom, you can do so by joining us on our Revolt server. The invite for that is in the YouTube page. You can just go to more, click here, and then you can go down and it's right here under the VSOF Revolt server. The other easier way to do this is if you go to Rumble and then you click on the About section, and you can go to download the entire welcome package, which you just copy this mega link, place it into your browser, and then you can go and download the welcome package, which will then teach you how to get onto the Revolt server and also teach you how to join Mega, which is where we hold class at, because it's an encrypted platform that the United States Federal Corporation can't get its hands on. Okay, so let's open up the treatise, and we left off on page 346, I believe it was. Let me scroll back up here. Yeah, we're on chapter 26, and this will be page 346 in the PDF. And you can find the PDF and follow along and download it. The link to all of the show notes for all of the classes for this entire reading will be in a mega link in the show notes for every class that you watch this on, whether it be on Rumble or whether it be on the other VSOF platforms. So to get started here, we are on a chapter called Presumption and Recital of Judgments as to Service of Process. Now, I read it today. It was an interesting chapter, but we're going to skip through this chapter kind of quickly. And I'm just going to cover the basis of what this chapter covers, but we're not going to spend a whole lot of time on it, kind of going over it in minute detail. So section 131, introduction. Even the writer of this particular treatise, this attorney who wrote this, is even stating that this subject is more than a little bit convoluted. Okay. So we approach a subject that has, to quote a satirist, been surely, quote, entangled in the web of the law. The conflict in the adjudications upon the question now to be considered is hopelessly irreconcilable. Now, just to make a point on that, hopelessly irreconcilable is probably something that they've probably gotten around to fixing, because remember, we are reading this treatise from the late 1800s, early 1900s. So the hopelessly irreconcilable situation of what we're about to talk about has probably been reconciled. Now, granted, it's going to be reconciled from a standpoint of what they've been telling everyone what the rules to do are under statute. There are going to be some things that we're going to talk about in this particular chapter and the one after, which hopefully we'll get to tonight, having to do specifically with the common law, which will not be changed and is consistent. So, all right, to continue. The courts which have announced one conclusion have been moved by the doctrine of absolute verity. And I actually had to look that word up today because I didn't know what it means. And basically, verity means that a truth that is well known, a truth that is basically accepted by everyone. That's what the term verity means. Okay, so the doctrine of absolute verity of judgments, while the authorities declaring the contrary view, are founded on the principle that right must prevail, though the solemnity of judicial findings be violated, which is not something you ever want to end up doing, but here we go. It is a contest between principles of policy, meaning public policy, and natural justice. Now, if it ever comes to a decision in my mind about which one of those two needs to prevail, it's always going to be natural justice, and public policy can always go to the wayside. So skipping down a little bit, it shall be our purpose to so present the subject as to extradite it from the confusion which surrounds it, and to deduce the true doctrine which should prevail. So first is judgments of other states. The provision of the federal constitution that, quote, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, close quote, and the act of Congress founded thereon that, quote, said records and judicial proceedings, ... in between, shall have such faith and credit given to them in every court within the United States as they have by law or usage in the courts of the state from whence the said records are or shall be taken, close quote. They have been the subject of extended judicial controversy. Even the National Supreme Court has not expressed the same opinion upon these provisions at all times. And if you've got the Supreme Court not exactly getting things right every time, you can kind of guess how convoluted this is. But so anyway, so again, so from reading that and the understanding of the Constitution, again, just what on earth is this entire chapter about? It's about the presumption and recital in judgments as to service of process. It means if you're in another state, let's just take New York and New Jersey for an example. Okay, so say you get a judgment in New Jersey and you're going to go do a service of process on some something in New York. And this is about the presumption that the New Jersey court, whatever their decision was, whatever their judgment was, is to be valid. It's to have full faith and credit, as the Constitution says, and how this goes about going on when it comes to who you're serving, when you're going and getting the stuff from somebody else, and so on and so forth. Okay. So just to make it a little bit clear as to what this chapter is. Now I'm going to skip all the way down to page 356 here. So again, like I said, there's a lot of stuff in this chapter that obviously is convoluted. And there's this whole section on the front that dealt with this very, very difficult case. And first off, it was an admiralty case and it dealt with a prize, meaning taking a ship a prize. And I don't want to get into all of the confusion regarding what a droit in admiralty is and how you go about doing a prize in admiralty court. I just kind of want to give the overall understanding of kind of what this chapter is so we can just get it behind us, honestly, and not have to get into that very long-winded discussion about that very odd case. So I'm just going to kind of skip it and just move forward as to what the purpose, what you should be taking away as a whole from this chapter and not get into all the minutia of it. All right. So for what purpose does the defendant question the jurisdiction of the court? Solely to show that its proceedings and judgment are void, and therefore the supposed record is, in truth, no record. The plaintiffs, in effect, declare to the defendant, the paper declared on is a record because it says you appeared, and you appeared because the paper is a record. This is reasoning in a circular logic. The appearance makes the record uncontrollable verity, and the record makes the appearance an unimpeachable fact. The fact which the defendant puts in issue is the validity of the record, and yet it is contended that he is stopped by the unimpeachable credit of that very record from disproving any one allegation contained in it. So it's ridiculous. And what they're getting at here is it's ridiculous to make an argument to say, well, just because the record says so that you say made an appearance in court, blah, 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 that the plaintiff automatically has the right to say a default judgment. Okay, that's not what is ever supposed to happen, because you can have irregularity in service. You can have incorrect process. You can have all kinds of things be incorrect, which makes the plaintiff not able to, by right, have a default judgment, right? So, but again, this is why this particular subject is so strange and convoluted. It's because even here you have this weird circular reasoning that doesn't hold up. And it doesn't hold up because as long as you directly attack any jurisdiction of the court, that matter, whatever it is, has to be settled before it's proven that the court has jurisdiction over whatever the hell it is that the plaintiff is trying to come after you for. And I don't care if this is the state of Texas in its capacity, like charging you with a misdemeanor, or if it's someone from Virginia suing you for a car, or it's some corporation that's suing you because, say a mortgage issue, like it's a foreclosure. It's about what is the proper process. Okay, so let's continue here. All right. Unless a court has jurisdiction, it can never make a record which imports an uncontrollable verity to the party over whom it has usurped jurisdiction. Now, there's a lot of court cases, and I didn't put them in, but I might add some after class. There's a lot of court cases that clearly state that a court that doesn't have jurisdiction can't, by its own record, just decide that it has jurisdiction. It has to be proven on the record. Much like, and of course, being on the side of a road with a cop is slightly different, but I'm going to use this as an analogy. The cop pulls you over and you say, you don't have jurisdiction over me. I'm not in commerce. And the cop says, I have jurisdiction over you because I have a badge, right? Well, that's the same thing as, say, the judge in court when you say, Your Honor, I'm here making a special appearance only to challenge the jurisdiction of this court. And the judge says something snippy like, I have jurisdiction over you and this court has jurisdiction over you regardless of what you say, or something like that. Hopefully not that you'd ever run into a judge that egotistical, but it's not that I haven't ever heard of that happening. So just because a court or just because a judge says they have jurisdiction doesn't mean they have it. And you have to object every single time they just try and railroad over you. So, okay. So with that said, I'll reread this. Unless the court has jurisdiction, it can never make a record which imports an uncontrollable verity to the party over whom it has usurped jurisdiction, meaning taken it without authority. And he ought not, therefore, to be stopped by any allegation in that record from proving any fact that goes to establish the truth of a plea alleging a want of jurisdiction, whatever that plea may be. And there's a lot of different ways to plead and go after these courts, particularly because they're all private for-profit courts now. They're all little corporations with their own Dun and Bradstreet numbers. You can literally sue the court itself. That's one way of going after them. And others are just motions to dismiss for various different reasons. And in superior courts, you also have what's called writs of error, which you actually sue out a writ of error to another court saying, hey, this other court didn't do what they were supposed to be doing, and I'm suing the court under writ of error to correct whatever it is that they didn't do correctly. So to continue, so long as the question of jurisdiction is in issue, meaning there's a question about it, the judgment of a court of another state is in its effect like a foreign judgment. It is prima facie evidence, but for all the purposes of sustaining that issue, it is examinable into to the same extent as a judgment rendered by a foreign court. Basically mean you can challenge the jurisdiction of it. If the jurisdiction of the court is not impeached, it has the character of a record and for all purposes should receive full faith and credit. Such is the prevailing doctrine in New York at this time. So basically, in a sense, what this is kind of saying is that, look, if you're not going to challenge the jurisdiction of the court and it looks like it has the character of a record, then for all intents and purposes, you should have full faith and credit. And wherever the final judgment is being served or the property is being taken, it should be seen as being a legitimate final judgment and have all the full authority of the law, right? Okay, so I'm skip down a little bit. As to jurisdictional matters, a judgment of one state may be inquired into when attempted to be enforced in another, and though it recite the due service of process on the defendant, it is not conclusive and may be contradicted. Meaning, if you're in another state and somebody comes at you and says, we've got a judgment against you from wherever, you can fight the judgment in the courts of the state of where you are at, is what basically this just said. And I know this is very important to a lot of people out there, especially a lot of single mothers and single fathers who have had their children stolen from them unlawfully by these private for-profit family courts, which are only there to create chaos and to destroy the American family. So I know a lot of you have gone through that who are listening to this, and some other parts of this chapter and then the one after are going to be important specifically for that reason, because a lot of the stuff that they're doing in these family courts is completely unlawful as to how they're saying that they have jurisdiction. And that's another reason why everybody needs to do their vocational science freedom status doc set, is to make sure that none of the presumptions that these private for-profit family courts are using against you can be sustained in their court. Because once you rebut the presumptions, they can't just willy-nilly do what they have been doing to everybody for basically the last 40 to 50 years. Okay, so, all right, now I'm going to skip down a bit to page 375. All right. Where the judgment recites that the defendant's appearance was entered by attorney, the authority of the attorney cannot be questioned. Now, why the hell is that important? Well, I put in a little note here. And this is why they always want to put an attorney on you in any criminal proceeding. If you take one, they, the attorney, will never properly attack the jurisdiction of the court. That's because they take secret oaths to the courts. And you will never be able to get out from under them, because you will then be seen as a ward of the court, and you will not be able to challenge jurisdiction properly on your own as long as that attorney is attached to your back like a parasite. Okay? All the more reason to never take an attorney, whether it's a criminal matter or otherwise. Say, nope, I'm not taking a public defender. Get out of my face. Okay, skipping down a little bit. To say that the record of a judgment can conclusively prove that any person was a party to the action in which it was rendered, and then to say that the judgment is conclusively valid because he was a party, is to reason illogically. Again, that same circular reasoning that they set up top. All right, so just be aware of that when they say, well, it says on the record, no. I'm challenging the record, right? That's why you have to put in your challenges. Okay, skipping down a little bit. Quote, I think that as to all domestic judgments, and this is Brewer J, or Horton J, sorry, who I believe is a justice. All right, so quote, I think that as to all domestic judgments, where upon the face of the record, everything is regular, the judgment rendered upon legal and sufficient service, it is conclusive as against any collateral attack. Public policy requires that judicial proceedings apparently valid should be held valid against everything but a direct attack. So that's again why it's so important, why you do a direct attack against the validity, against the jurisdiction of all these private for-profit courts. Because if you just bring it up a few times, say in court, like verbally, but you never file an official motion, you never put the motion in for hearing, you never say go above and beyond that, meaning like you actually sue the court for jurisdiction, or you never properly put it as a counterclaim in a proper court of record, which proceeds according to the course of common law, which is above all of these inferior courts that proceed not according to the course of common law. If you do not sue them in a court of record or do the other things that I just said, you will not have directly attacked them. And that's exactly what needs to happen every time. So just pay attention to that. Know what you need to do, learn how to do it, and do not hesitate to do it, and don't forget to do it. Because, like again, just like I said, if you just say it in court, oh, I don't agree to the jurisdiction, or I don't consent to the jurisdiction of this court, which is something good and something you should say, but it's not going to be a part of the official record wherein other people that read the record are going to say, oh, jurisdiction was actually challenged, and the court never proved it. No one's going to go back and read the transcripts. Judges don't do it. Certainly cops don't do it. They just get an order and they just follow it. So things that are stated in transcript just get lost. And a lot of time, things that are stated in transcript, they get recorded incorrectly because they lie in what you said in the transcripts. Can't tell you how many times people have sent me transcripts and they said, I didn't say this. I'm like, I get it. I totally understand. They pretty much write down what they want to write down. So anyway, to continue. Section 138, distinction between irregular or defective notice and no notice. There is a well-founded distinction between no service and irregular or defective service, the latter rendering the judgment voidable only. And where the notice is merely irregular, if the court decides it to be sufficient, the judgment cannot be collaterally attacked. So, okay, between no service and irregular service or defective service, if you've never been served, obviously the court doesn't have jurisdiction. But if they try and move forward and do it anyway, that's something that you can attack even after judgment, because obviously if you never got served, you didn't even know that you had to defend against anything. But if it's an irregular or defective service and you never brought up any issue, well, then they're going to move forward without anything looking as though there's any problem there. Okay. All right. So skipping down a little bit. Section 139, foreign judgments. By the term, quote, foreign judgments is meant judgments of other countries. They are but within the common law rule of prima facie evidence and are not conclusive as to jurisdictional matters. Meaning, like if you had a judgment from, say, France or something, and then you brought it here, like say somebody got divorced in France and then there was an issue in America that had to do with property and you brought it, well, it would be prima facie evidence and not conclusive as to jurisdictional matters as to whether the court in France had jurisdiction or not, is what they're getting at. Okay, skipping down a little bit. The court said, quote, while the judgment of divorce appears to have been granted by a competent tribunal, which had jurisdiction of the subject matter as well as of the parties, and is therefore entitled to liberal presumptions, it is not so far conclusive as to preclude the plaintiff from showing that it was rendered without jurisdiction or was fraudulently obtained. The reply specifically denies that the plaintiff was ever served with process or had her day in court in any of the proceedings mentioned in the defendant's answer. If in truth there was no service, personal or otherwise, and she had never been given an opportunity to be heard, she cannot be bound or affected by any of the orders or judgments made in those proceedings. A foreign judgment rendered without jurisdiction may be assailed in either a direct or a collateral proceeding. Okay, so this has to do with any court order, any court matters that happen in any other country. And remember, the states to each and each other are technically foreign countries to each other. That's why they have governors. Okay, but we have the federal constitution, which states what I stated earlier, that they're given full faith and credit for all other matters in between said states, said countries. Okay, and such is a universal law. All right, next section. The author's view upon the subject of this chapter. To say that foreign judgments and judgments of other states are prima facie evidence of jurisdictional matters and may be impeached in this particular is but to repeat what we have already declared in preceding sections of the chapter. There is no ground for controversy upon this proposition, so far as concerns foreign judgments. And while there are numerous and most respectable authorities which favor and enforce the absolute verity of judgments of other states, we willingly accept and approve the decision of our national tribunal that judgments of another state are not conclusive as to the jurisdiction of the courts which rendered them, either by reason of presumption or express assertion. Such conclusion is more satisfactory to our mind and is entirely in accord with the principles of the written and unwritten law, which I completely agree with. You shouldn't just automatically take at face value that every judgment from some other court in some other state actually had jurisdiction to do whatever it was that they did. The question is to be concerned and answered upon the fact that the defendant had no notice of the proceeding in which the judgment was rendered. The distinction between irregular notice and no notice, as explained in the second preceding section, being substantial. To render judgment against one without any notice and then compel him to submit inevitably to its requirements is against every principle of natural justice and cannot find justification in the principle of public policy either, obviously, because no notice is no jurisdiction. The contest is purely between the principles of natural justice and public policy. And after much labor, investigation, and thought, we prefer to subscribe to the former and assert that a judgment rendered by any court against one without notice should never be permitted to be used as an instrument of injustice. And when sought to be enforced and is attacked collaterally, the question as to whether the court which pronounced it did actually have jurisdiction over the defendant should be considered and determined. Exactly. And how are they going to determine that? They're going to read the fucking record. So if you don't have anything on the record, there's nothing there for anybody ever to bring up any question. Because again, no one is going to go get the transcripts and start reading them. In fact, the transcripts aren't even necessarily in the court case unless someone's ordered them and put them in there. They're just hanging around on tape somewhere. No one reads them. So unless there's been a motion or collaterally attacked that inferior court, it's not going to show on the record that there was ever any challenge to jurisdiction. Okay? So make sure that you make one. All right, to continue. In considering the conflict between the principles of natural justice and public policy here presented, and the fact that the latter have largely prevailed, we are reminded of Chancellor Kent's aphorism, quote, "Human laws are not as perfect as the dictates of conscience, and the sphere of morality is more enlarged than the limits of civil jurisdiction," close quote. Those decisions which have advanced from the rule of absolute verity so far as to assert that the question of jurisdiction must be tried by the whole record, and that if it show a want of notice to the defendant, meaning he never got served, the judgment will not be enforced, are certainly beyond criticism and have tended to promote the administration of justice. Where, however, it is sought to annul a judgment in a collateral proceeding on the ground that the defendant was never served with process, the effort should never be permitted to prevail unless the want of notice be shown by such positive, weighty, and conclusive evidence as to leave no doubt whatever that the charge is true. Meaning, you're in another state, comes along, somebody's got a judgment, and you just kind of bring it up there and say, well, he never served me. It shouldn't just stand. You have to bring in evidence, right? And the other side has to bring in evidence too. Like, I've never got this. I don't live there. I've never been there. I'm not even this guy, whatever the case may be. So to continue, nothing should be left to conjecture or uncertainty. The presumption of the validity of the judgment would demand the clearest and most convincing proof to overcome it. Otherwise, it should prevail, meaning that the guy should get his stuff and the plaintiff should do whatever he needs to do. Okay. All right. So that's blasting through that chapter real quick. All right. Next one, chapter 27, constructive or substituted service of process, publication, posting, mailing. So this chapter is where everybody gets to learn that you can do service of process by mail, but only in certain circumstances. You can also do service of process by publication, which is where you put the various different notice that someone and so forth is getting sued in a newspaper. If anybody still reads newspapers anymore, I don't know. But if you do, if you find the state journal for whatever state you're in, particularly on Sunday, you'll see a lot of notices. Go to the notice section. You'll find a lot of notices by publication, meaning somebody's getting served or some estate is being taken care of and they don't necessarily know where everybody is or they cannot serve everyone. Well, then you need to get leave from court in order to do lawful process service by publication or posting or mailing. And that's what this chapter is going to talk about. Okay. Section 141, Introduction, Constructive or Substituted Service, Kinds of Authority for. We have now to consider the method of service of process known to the law as constructive or substituted service. The common manner of effecting such service is by publication, that's by newspaper, by posting the process in a public place, which normally is, strangely enough, the post offices, or inserting it in newspapers, the most usual method being through the medium of newspapers. Serving process through the mails is also resorted to in some states, this being usually ancillary to the publication of summons, meaning you do both at the same time. The cases are in conflict as to whether service of process, by leaving copy thereof at defendant's usual place of abode, is actual or constructive or substituted service. However, the terms as used in this chapter will be to designate service other than by leaving a copy of the process at the defendant's usual place of abode, of which we have written in a preceding chapter. I'll skip down a little bit. Personal service of process out of the state, which is warranted only in proceedings in rem, is constructive service and is equivalent to publication of summons. So when you're doing this out of state, you can only do it in an in rem action. You're really not supposed to do it at all unless the statutes say you can do so in any action in personam, meaning against the person or the man, okay? All constructive or substituted service of process must, to be effectual, be authorized by statute. It is a manner of serving process unknown to the common law. That's why I highlighted that twice. So when you are doing a court of record action, you cannot do this. You cannot do service by publication and you cannot do service by mail. You absolutely have to find the man and give it to him. Okay. Such service is, as a rule, authorized to be made on non-resident defendants and is of validity only in proceedings in rem. Again, an in rem action is against a thing or a res. It is justified also against parties who cannot be found within the jurisdiction of the court, though they may reside therein, or who proposedly seek to evade process, meaning they're trying to get out of being served. The presentation of the subject of this chapter must necessarily be limited to a consideration of statutory provisions, their construction, force, and effect. This may be best done by a statement of the points determined in the numerous cases concerning the subject. Section 142, the affidavit preceding constructive notice, sufficiency, validity, and amendment of. The authority for all constructive or substituted service of process is to be exercised only after showing that the defendant is not within the reach of personal service. This is usually evidenced by affidavit, which may be considered a necessary prerequisite to the validity of such service. An affidavit stating that the affiant, and that's who is someone who makes out an affidavit, is an affiant, is ignorant of the place of the residence of a party does not sufficiently show that he cannot be served personally and will not support an order of publication. So this is stating, again, that you got to go to the court, ask permission in order to do service by publication. And it can't just be, oh, well, I can't find him. It's got to be better than that. It's got to be, I tried 4 or 5 times at his house. He's no longer at his workplace. And it's even better if, you have someone that could say as an affidavit, yeah, I know that he moved to Iowa or something, right? That he is out of here. That's what you're looking for. That's what you need to be able to do to prove to the court that I need permission to serve this guy by publication. Okay. Neither is it sufficient that the affiant merely state that he, quote, is informed and believes, close quote, that the party, quote, is not a citizen of this state, close quote. It must be stated positively the defendant is not a resident of the state. And it was said of an affidavit that contains statements that the defendant could not by due diligence be found within the county, that affiant had acquired of defendant's friends who gave no information as to his whereabouts, and that he did not know where the defendant could be found within the state, that it did not show that the defendant resided out of or could not be found by due diligence within the state, or had departed or concealed himself, and was insufficient. So in that situation, it's even saying you can't even just get somebody else to say it. You really do have to prove it, right? The facts required by the statute to exist to warrant service by publication must be stated positively. The affidavit required to support an order of publication of summons must contain a statement of some fact which would be legal evidence having some applicable tendency to make the fact of jurisdiction appear for the court to act upon before it has any jurisdiction to make the order, semicolon, and unless the affidavit contains some such evidence, the order of the proceeding under it are void. To verily believe the existence of a fact is not sufficient. Where service is made by mailing the process or a copy, the affidavit must show that the address was that of the usual residence of the defendant and that the mailing was in sufficient time for the defendant's appearance. Meaning, and why is that important? It's that you can't use service by publication to alter the time frame of which the defendant has a right to answer whatever it is you're suing him with. I mean, you can't grind down or cut off the defendant's clock to answer just because you're doing this method of service, okay? So skipping down, a statute requiring proof of non-residence of defendant to be by affidavit is not satisfied by basing an order for publication on merely the non-est return of the sheriff, meaning sheriff says, oh, I can't find him. Say, okay, well, that's obviously not good enough. You have to do more than that or put more than that into the affidavit. So the point here being that you should check the statutes in your state as to when you can do service by publication and make sure that if there is any requirements needed by the filing of any document into the court, that you do so before you do service by publication, or else it's not going to get you what you want. You're not going to be able to lock it down. You're not going to be able to have a default judgment, and so on and so forth, okay? All the statute requires to be shown must be shown. A strict compliance with the provisions is required. Now I'm going to move down to 386 because we're going to skip through a little bit of this too. No presumption is to be indulged in favor of jurisdiction. The affidavit must clearly set forth the statutory grounds on which the order is authorized to be made. It is not necessary that the affidavit show the language of the statute. A statement of essential fact is sufficient. Skipping down some more. If there is a total want of evidence upon a vital point in the affidavit for publication, the court acquires no jurisdiction by publication of the summons. But if a material fact is inadvertently or insufficiently set forth, the proceedings are merely voidable. So do it right. If you don't do it right, they're voidable, meaning the other party can protest. But if there's a total want of evidence, then it doesn't give the court jurisdiction, is what they're saying. All right, skipping down to 390. A judgment in an action in which service by publication is had with an affidavit being made that personal service could not be had on the defendant within the state as required by statute is void. Again, can't do this properly, then don't try to put it into the court because it's just going to come back. The other party's going to throw it out. Skipping down, where no affidavit is filed, the court order for publication will be invalid, which is obvious, but I just wanted to highlight that little part. Skipping down to 396. As again, we're obviously going through this chapter fairly quickly as well, because there's a lot of aspects and a lot of stories, a lot of court cases in treatises on law that when you're reading these older treatises, what you're trying to look for is the meat of what you're trying to learn about the subject. You're not trying to go into the minutia of all the tiny little cases that are given. It doesn't help you. A lot of them might have been overturned or altered anyway. All you're looking for is the substance and the simple purity of the information to learn the subject is what you're looking for, which is why I'm skipping along the way I am. So, all right, to continue. A lapse of 5 days between the making of the affidavit and the granting of the order for the publication has been held to render the latter ineffectual, since the order must be based on facts existing at the time it is made. Now, I thought that was kind of shocking. So a lapse of 5 days. So you put in the affidavit to the court, and then you go and you make the publication 5 days later. Apparently that's not good enough. So apparently you have to drop the affidavit into the court, get the court order, and immediately go and put the publication into the newspaper the same day is what it's sounding like. So just be mindful of that. Also, just a little note here. So for service by publication to be done correctly, it must be done the same day. That's what I have as a note. And also just make sure to double check that the statutes say what they say regarding issuance and service by publication. Case in point, if the statute require the affidavit to be made by the plaintiff, it cannot be made by his attorney. A consideration of the authorities cited in support of the various propositions announced in this section produces the central thought that constructive or substituted service is the creature of statutes, right? Because we know that we can't even do it at law. It's something unknown at the common law, which are in derogation of the common law and which are to be construed and must be followed strictly. So, and that's the thing about, just as a side note here, that's the thing about all statutes. All statutes, acts, ordinances, and codes, if they're not followed absolutely correctly to the absolute point of everything that's stated in the statute, then they're void. You didn't do it correctly. And where matters of common law can be a little bit more lenient. Because honestly, when you're doing something at law, you're really focusing on one thing, one point, to get it down to one single point by going back and forth with the other party to finally say, okay, you say this and I say that. And this fact, whatever it is that I say happened and you say didn't, this fact is now at issue, and everything else in this court case has been agreed upon between the parties. That's how you work a case at law. You go back and forth and back and forth and back and forth. Do you agree to this? Yes, I do. Do you agree to that? No, I don't. Okay. Well, here I've got this evidence. Okay. Do you agree to it now? Okay. Yeah, I do. All right. Do you agree to this? No, I don't. Okay. Back and forth, back and forth. It's a lot more back and forth paperwork to whittle it down to, you're trying to whittle it down at law to literally a single point. Now that doesn't always happen. Sometimes there's a lot of things that the other party doesn't agree to, or they say, no, I didn't do this, didn't do that, didn't do this, didn't do that, whatever. Well, there's ways to take care of that at law. But so at law, you're kind of trying to whittle it down to a single point, where in statutory construction, everything has to be followed absolutely correctly in the beginning, or none of it's valid. So just remember that when you look into and start reading statutes, okay? Particularly if the state is saying that they somehow apply to you. Okay, section 143, the order for publication or other constructive service. When by affidavit or in any other manner the statute may require, the statutory and jurisdictional facts have been established. The next step in the proceeding for constructive service of process is the order of the court that service of the writ shall be by publication, posting, or mailing, as the statute may require. Such order should be carefully prepared, notwithstanding every presumption favors the validity of any proceeding in a court of general jurisdiction, which is a court that can pretty much hear all matters, meaning not a court of special jurisdiction. All right, skipping down. In order for the constructive service of summons on a non-resident which fails to designate the post office in which copies of the summons, complaint, and order shall be disposed for transmission to the defendant as required by the statute is insufficient. So again, this is an aspect of that. You can put these things, you can put the notices up in post offices as well. Now, nobody really does this anymore, but the federal government sure did it when they stole everybody's gold in 1933, because I have a copy of that notice and it's sitting on my wall. So they definitely did service by publication on everyone in 1933, just to make sure everybody got the point that we're going to steal your gold and there's nothing you can do about it. So, but you don't really see that too often anymore. But if you go into any post office, talk to the postmaster, they will always have a board of which you can put up public notices, because this is part of that. Okay. All right, to continue. Omitting to direct a copy of the complaint and summons to be mailed to the defendant and to specify the length of time for the publication, such being required to be contained therein by statute, renders the order void. So if you're not doing these things, even if the court puts it in order, it's not valid. Skipping down, the date of entering an order for constructive service of process may, in the discretion of the court, be amended to conform to the facts. This kind of means that you can sort of, if by leave of court, you can kind of go back and ask them to redo it again, because service of process is this thing where you're going to be doing it over long periods of time, like for weeks on end, into post offices and into newspapers. So if you kind of mess something up, it's not the end of the world. You can kind of go back and redo it, is what that's saying. All right, so now we're going to skip down to page 403 and section 144. When constructive service is authorized and granted, the right to serve summons by publication on a non-resident is not defeated by the fact that he was in the habit of coming into the state as often as once in 2 weeks. So if somebody's just kind of coming and going, but they don't really have another domicile someplace else, well, that doesn't really get you off of having to be able to serve them. You kind of have to catch them. Under the statutory provision that service of summons may be made by publication when the defendant resides out of the state or has departed from the state or cannot after due diligence be found within the state or conceals himself, and that fact appears by affidavit, it is not necessary to show an attempt to find a defendant in the state or to return of an officer that he cannot be found if the affidavit states that he resides out of the state and gives his residence. So again, if you can prove he lives someplace else, that's pretty easy. Just put it in the affidavit. All right, service process. You can do it by publication. Done deal. I think personally that you should actually just, because nowadays it's pretty easy with all the communication that we have and all the process service people that are out here. You can easily hire a process server pretty much anywhere to have it go and served, particularly if you have the address. So doing service by publication, just because he lives in another state, even though you know his address, is, in my personal opinion, pretty shitty. You shouldn't really do that to someone. You want them to be served. You want them to have their day in court, and you want them to be able to defend themselves. Because usually you're not filing a lawsuit against anyone who clearly didn't do something incorrect and wrong to you to begin with. So that's why you're making it public, which is why we even hold court. It's just civil warfare, as Bill Thornton used to say, and hopefully does still say. I think Bill's still alive, yeah. So under the code, so to continue, under the code provisions authorizing service of summons by publication where the defendant resides out of the state or has departed from the state, such service is rightly made when the defendant is but temporarily out of the state. Right. So again, got to catch him. Skipping down to page 411. A non-resident minor may be served by publication. Now, why the hell is that important? Okay. So we are all seen to be minors within the scope of the definitions and the statutes. The answer is yes. Particularly under Title I, United States Code subsection 8, under the definitions, under the word person. We're all considered to be infants, right? So you're a non-resident minor, maybe served by publication. Where is your residence presumed by presumption to be? In the District of Columbia. So you're considered to be a non-resident minor anywhere you are by presumption. So can they do this to pretty much anybody? Yeah. Do they do it to people? Yeah. That's exactly what I was getting at with the state, quote unquote, state courts, state family courts, doing what they're doing. They do this shit all the time to steal children because the family courts are a human trafficking racket. But anyway, to continue. To authorize an order from the service of summons by publication that the defendant cannot, after due diligence, be found in the state, such being the statutory condition, must be shown by affidavit, as we've said multiple times. Certainly, service of process. Oh, sorry. And I'm going to read the footnotes here because this is a very long and interesting thing in the footnotes, and I'm going to come back to here to continue the chapter. All right. So this is Bardwell versus Carlins. Okay, so, quote, the only remaining question, therefore, is whether it is competent for the legislature to authorize such service in such actions upon residents of the state personally present and capable of being found and personally served within its jurisdiction. Is such service due process of law? In determining this question, it becomes important first to consider the character of an action to foreclose a mortgage. It is not an action in rem, but an action in personam. It is true, it has for its object certain specific real property against which is sought to enforce the lien of a mortgage, and in that sense, it partakes somewhat of the nature of a proceeding in rem, but not differently, or in any other sense, than do actions in ejectment, replevin, or specific performance of a contract to convey, to determine adverse claim to real estate, and the like. The rights and equities of all parties interested in the mortgaged premises are to be adjudicated in the action, which proceeds not against the property, but against the persons. And the judgment binds only those who are parties to the suit, and those in privity with them. Next, it is not only an action in personam, but it is also strictly judicial in its character, proceeding according to the due course of the common law, like any other ordinary action cognizable in courts of equity or common law. These facts are important for the reason that would be due process of law in one kind of proceeding might not be such in another, for reasons that we will allude to hereafter. Quote, no court has ever attempted to give a complete or exhaustible definition of the term due process of law, for it is incapable of any such definition. Now think about that for a second. We are reading an entire treatise, skipping through an entire treatise of 742 pages on this subject. It took 742 pages of an attorney, probably writing for several years, to put this understanding of what due process is down on paper. So there can never be just a simple definition of it, okay? It's everything that we're talking about in this treatise, all of it. So to continue, all that can be done is to lay down certain general principles and apply these in the facts of each case as they arise. Mr. Webster, in his argument in the Dartmouth College case, gave an exposition of the words law of the land and due process of law, which has often been quoted by the courts with approval. Vis-a-vis, the general law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. In judicial proceedings, due process of law requires notice, hearing, and judgment. That's basically as close as you can get to a short definition right there. In judicial proceedings, due process of law requires notice, hearing, and judgment. Those are the three things. You got to have it, or else you're not properly bringing due process. It does not mean, of course, the general body of the law, common in statute, as it was at the time the Constitution took effect, for that would deny the legislature the power to change or amend the law in any particular. Neither, on the other hand, does quote, the law of the land, or, quote, due process of law, mean anything which the legislature may see fit to declare to be such. An important point. For there are certain fundamental rights which our system of jurisprudence has always recognized, which not even the legislature can disregard in proceedings by which a person is deprived of life, liberty, or property. That's an extremely important point, particularly because it was said by Webster. And one of these is notice before judgment in all judicial proceedings. Although the legislature may at its pleasure provide new remedies or change old ones, the power is nevertheless subject to the condition that it cannot remove certain ancient landmarks. What the hell is a certain ancient landmark? Common law, the ancient aspect of common law interwoven with natural law, that we have natural law rights. From time immemorial, before courts existed and before governments existed, particularly the governments that we created here in America. So, to continue, or take away certain fundamental rights, which have been always recognized and observed in judicial procedures. Hence, it becomes important in determining what kind of notice would constitute, quote, due process of law in any judicial proceeding affecting a man's property, to ascertain what notice has been required and deemed essentially necessary in actions or proceedings of that kind, according to that system of jurisprudence of which ours is derivative. In proceedings in rem, that's against a thing, as in admiralty and the like, where the process of the court goes against the thing, not the person, which is in the custody of the court and is technically the defendant, and persons are not made parties to the suit, meaning they never got notice, but come in rather as interveners, it is not essential to the jurisdiction that the persons having an interest in the thing to be affected by the judgment should have personal notice of the proceedings, or in fact any other notice than such as is implied in the seizure of the thing itself. Now, that sounds like crazy and it sounds like unlawful, but when you get into weird stuff like admiralty and you think about things like flotsam and jetsam, which are things that get thrown overboard in a ship, right? So say you get a ship sailing, and this even happens today in these massive tanker ships. Some huge tanker ship gets rocked at sea and some latches break and whatnot. And you have 10 or 15 or 20 or God knows how many of these enormous containers, shipping containers that you see on like the backsides of freight trains falling off into the ocean. Okay. If that fell off into the ocean, you come along with a boat and it's sitting there floating, you have no idea what it is, where it is, whatever. You have right to claim that thing because it's abandoned property rights. And also it has to do with a whole bunch of other stuff I don't want to get into regarding admiralty. But the point is that the suit would be against the thing. You have no idea whose it is. I'm making a suit against this thing. Does anybody bring claim to it, right? So on and so forth, la, la, la. Well, that's how you do that. And that's the aspect of having this aspect of an in rem action against a thing, okay? Okay, to continue. There are other proceedings in the nature of proceedings in rem, many of them not strictly judicial, and none of them proceedings according to the course of the common law, such as the probate of wills. Such as the probate of wills. What are they doing to all of us at all these courts? Just probating our will. That's all they're doing because no one's come forward and claimed our estate. But anyway. Administration of the estates of deceased persons. Again. Or what? Persons that are infants. Persons that are perceived dead by presumption. Again. 5 years, don't come back, claim your estate. It's a presumption, you're dead. So we're just going to put all your stuff in a constructive trust and then basically administer you till you're actually dead. But anyway, to continue. The exercise of the right of eminent domain. The exercise of the power of taxation, which affect property rights, but in which personal notice to persons interested in the subject or object of the proceedings has never been deemed necessary. So think about that. Some form of substituted service of notice as by publication has always, from considerations of public policy or necessity, been deemed appropriate in such proceedings, and hence, as to them, due process of law. But we think that, from the earliest period of English jurisprudence down to the present, as well as in the jurisprudence of the United States derived from that of England, it has always been considered a cardinal and fundamental principle that, in actions in personam, meaning against the person, proceeding according to the course of the common law, personal service, or its equivalent, as by leaving a copy at the usual place of abode of the writ, process, or summons, must be made on all defendants, resident and to be found within the jurisdiction of the court. We do not mean that the term proceeding according to the course of the common law as used in the books is to be understood as meaning necessarily and always personal or actual service of process. For, although service by publication is of modern origin, there has always been some mode by which jurisdiction has been obtained at common law by something amounting to or equivalent to constructive service, where the defendant could not be found or served personally. Now, to make a pause here, there's actually a part of this that goes back to Roman civil law as well. Under Roman civil law, what they used to do is they used to come before your house and yell at you, or basically yell at the house. So anybody that was also around in the area, meaning neighbors and servants of the house and whatever, everybody heard you. So that was how they did it in Rome, which I find interesting because it kind of comes through from the standpoint of what we still have the capacity to do at common law. So, but to continue. But we do not mean to assert that the right to resort to such constructive or substitutive service in personal actions proceeding to the course of the common law rests upon the necessities of the case, and has always been limited and restricted to cases where personal service could not be made because the defendant was a non-resident, or had absconded, or had concealed himself for the purpose of avoiding service. As showing what means were resorted to as amounting or equivalent to constructive service, and how strictly it was limited to cases of necessity by both courts of common law and courts of chancery, reference need only be had to Black's Law commentaries, those particular sections. Quote, as a substitute for the means formerly resorted to in England in such cases, most of the American states have adopted service of the process or summons by publication. But we have found no statute except the one now under consideration, which has assumed to authorize such a mode of service, and have found no case where its validity has been sustained by the courts, except as to defendants who could not be found within the jurisdiction, either because of non-residence or because they had absconded or concealed themselves to avoid the service of process. We think this will be found true in every instance from the earliest decisions on the subject down to the latest utterance of the Supreme Court of the United States in said case, in which the court took occasion to set the rest some misapprehensions as to the scope of their previous decision in Hart versus Sampson. We think it would be a surprise to the bench and to the bar of the country if it should be held that the process or summons of ordinary civil actions might be served on resident defendants present and capable of being found within the jurisdiction of the court merely by publication in a newspaper. The dangers and abuses that would arise from such practice are too apparent to require to be named or even suggested. Exactly. So radical a departure is this from uniform and well-established ideas of what constitutes due process of law in such cases that although this act has been on the statute books for 24 years, we doubt whether one lawyer in 20 is aware of its existence. And we have yet to hear of any case except the present where anyone has ventured to act upon it. It is, in our judgment, beyond the power of the legislature to disregard so fundamental and long established a principle of our jurisprudence. See, this is the Supreme Court saying that attorneys can't just do whatever they want to do, and legislatures can't just do whatever they want to do either, not if it's in violation of the common law. Okay. Service by publication under such circumstances is not due process of law, and therefore any statute assuming it is unconstitutional. It would be of little use to cite authorities upon a subject which has been so much and so often discussed in its many phases, as each must determine upon its own facts, and hence decided cases would ordinarily be in point only on way of analogy, because you can't really decide and do cases on stuff that of a statute that just got put into creation. Okay, so that was that very, very, very long aspect of that was literally the footnotes that I was just reading. Okay, now I'm going to come back up here. All right, so certainly service of process against the defendant, resident of state, can be authorized only when he cannot be found or is absent or conceals himself to evade process. And this, of course, only in actions in rem. So again, this is the problem. But what are all actions against, quote unquote, you now? They are all actions in rem because they're all against your estate or against a constructive trust that took some res from your estate. So just remember that. Section 145, the notice, its insufficiency. In proceedings based on the constructive service of process, the notice that is usually published is a copy of the order of the court or officer granting it, while the matter posted or mailed is a copy of the summons or copies of both the summons and complaint. It is the notice that is published in newspapers, however, that is of special interest and importance. So I'm going to reread this again because this is kind of the point of the whole entire chapter. It's pretty much just about this. In proceedings based on the constructive service of process, the notice that is usually published, meaning published in the newspaper, is a copy of the order of the court, which you already went to go get and have in your hand by filing an affidavit properly according to the statute of whatever it says to be able to go and get this order from the court originally. Okay. So it's a copy of the order of the court or officer granting it, while the matter posted, meaning what you're putting into the newspaper or mailed, is a copy of the summons or copies of both the summons and complaint. It is the notice that is published in newspapers, however, that is of special interest and importance. So just remember to get that right. Is if you ever need to do this, that last paragraph was the single most important paragraph of this whole chapter. Okay. This little thing, a citation made by publication against McKee will not support a judgment against McRee. The names are not idem sonans. So, idem sonans is a legal doctrine whereby a person's identity is presumed known despite the misspelling of his or her name if the misspelled name sounds the same when pronounced. Second note, this is the reason why we put this term into all of the Vocational Science of Freedom status doc paperwork. We state this because the attorney likes to change a thing by changing the capitalization of the thing and rearranging the order of one's proper name to say, create a constructive trust from one's estate name. Like Doe, John Henry, right? Or something of that way. They reverse it. Or they'll put the capitalization in all caps of something that we know to be, or shouldn't be, let's say, a person, not your proper name. Well, guess what? They just turn it in constructive trust. Or the name on the birth certificate is the name of the estate, which they then take res out of and turn into a constructive trust, which they then sue in a court case. That's how they do all this. So it's very important. That's why I put that term, that specific Latin term, idem sonans, within all the status doc paperwork, so that it doesn't matter how we're stating it. It doesn't matter how they state it. We are claiming the whole entire state, no matter how the fuck it's written. I don't care. So, all right, off my soapbox. I think this is the last section. All right, section 145, publishing the notice. The newspaper and time. It is to be remembered that in subjecting parties to the jurisdiction of a court by constructive service, the statute requirements must be strictly construed and followed in every part of the proceedings. Though the publication of the notice be extended beyond the time required, this will not continue the time when the defendant is required to answer. As I said, you can't use service by publication to mess around with the defendant's clock to answer. Okay. Skipping down, the publication of a notice 6 times in a weekly newspaper constitutes service on the defendant 42 days from the date of the first publication. A record showing the order of publication to have been made on January 25th and that judgment was rendered on February 22nd, it was held that, on collateral attack, the publication of the notice for 3 weeks, as required by statute, would be considered to have been made. So again, my note. So make sure to check your clocks. What the hell do I mean by a clock? I mean, there are certain things that are done in law that you have to do within a certain period of time. You need to keep good calendars when you're doing suits at law, when you're suing corporations, when you're suing anybody, when you're even giving a notice of to someone. And very specifically when you're serving the Vocational Science of Freedom status doc set, because it has clocks within it. All of you that have already done the Vocational Science of Freedom status doc set, make sure that you go and reread the kill warrant. It's got a very specific set of clocks in there, which need to be followed, both by you and by them. If they default, you can then take them to binding arbitration, which is why I wrote it the way I wrote it. Okay? So keep track of your clocks. All right. Skipping down. The publication of the notice on a paper other than specified in the order of the court renders the service ineffectual and jurisdiction is not obtained. And this without regard to whether the defendant was prejudiced. So if you don't put it in the proper newspaper, as per what the statute says, it doesn't work. So make sure you check your statutes. Next section, proof of publication. In many states, the statutes provide for proof of constructive service of process by affidavit of someone connected with the newspaper in which the notice was published. But this is not an exclusive method unless made so by statute. Okay, so what does that mean? Provide for service of constructive service of process. So basically what you're getting from the newspaper company, that's what they're talking about. So proof of publication is you get an affidavit filled out from the clerk of the newspaper company. And I've done this before, and it's not a big deal. You just they ask you all the time anyway. Whenever you're publishing something in a newspaper, they'll usually flat out ask you after you fill out all the paperwork and tell them what you want in there, or whatever. And specifically, if they see it being like a legal notice, they'll say, "Do you need an affidavit with this?" And you say yes, because then that's what you take back to the court to prove as to the date when you first made the publication. And that starts the clock. But you got to have that affidavit. So make sure that you get your proof of publication from the newspaper, okay? In order for publication appearing on the record and an entry that such order was published in a newspaper, naming it, will be presumed that proof of publication was duly made. An affidavit as to proof of publication made by a clerk in a newspaper office, which shows that he was the only clerk there, satisfies the law, which requires the affidavit to be made by the quote-unquote principal clerk. But when made by the principal clerk, he must positively assert that he is such. To simply recite in the opening, quote, the affidavit of the principal clerk, close quote, is insufficient. Where the proof is required to be furnished by the editor of the paper, the duty cannot be performed by another. And I think, I don't necessarily hold me to this proper, but I'm pretty sure by now, since service by publication has been such a thing for such a long period of time now, that I think pretty much every state statute is going to say the same thing. And they're probably going to get rid of all of these little nuances about, oh, it's got to be the editor of the newspaper. It'll probably just say affidavit by a clerk of the newspaper or something to that aspect. So again, just read the statute and check your court rules regarding your service by publication. And skipping down, the judgment of a court which has jurisdiction of the subject matter and requires jurisdiction of the person by notice published as required by law is as final and conclusive as if actual notice had been given. This declaration means, of course, so far as the rem, which is the subject matter of the action, is concerned. So remember, guys, you're really only doing this on aspects of in rem action, but since they're doing everything by in rem and considering aspects, remember, of a state are aspects in rem. We just read that tonight. Notice that. So everything they're going to try and be doing to you is going to be an aspect of an in rem action. Being put through a private for-profit court, running everything through probate because no one goes and ever claims their estate. So you don't want any of this nonsense to come upon you. The first thing you need to do is properly correct your status. And you can do that by joining the Revolt server and then sending email to me at VSOF@protonmail.com, and we can get you set up and get you started. And all of the documents and all the other services that we provide for the Vocational Science of Freedom can all be found in the welcome package when you get to the VSOF on Revolt, and also you can find it in the About section again on Rumble. Okay, I think I will stop it for this evening. So this will be the end of Class 9. And next week we'll start up again, Class 10, and we'll probably make our way through this in the next couple classes. So, and I know some of you are getting a little tired of listening to this stuff, but I'm just doing it for posterity so that everybody has the capacity to come back and listen to this if they need to, so that they really do understand how to serve people, because it's extremely important information, even if it's a little bit dry. So thank all of you very much for listening. Hope all of you have a wonderful rest of your weekend as always. And until next Saturday, stay safe and stay sovereign.
Oh, say, can you see?